Prova. Prova. La telecamera non si gira però. Ecco. Okay. So we can start. We can start the second seminar organized by the UNESCO Chair on Intangible Cultural Heritage and Comparative Law of the University of Rome Unitelma Sapienza, Department of Law and Digital Society. Today, the topic is human cultural heritage as a human rights. And today we have the opportunity to discuss about this very relevant topic with two different speakers, Professor Lukasz Lidzinski and Professor Remidas Louzikas. I hope that my pronunciation is correct. Unfortunately, our colleagues from Brazil, she cannot be part of this seminar for technical problems. But I'm sure that we will have a strong debate after the true presentation of our friend Lucas and Remidas. Just a few words to introduce the seminar today. As you probably know, the UNESCO Chair on Intangible Cultural Heritage and Human Rights is a chair composed of anthropology, historians, and lawyers. One of the idea on the basis of the UNESCO Chair is that cultural heritage is a human right. When we started with our research more than 15 years ago, the idea to consider cultural heritage as human rights was not really a common idea. Probably starting from the resolution adopted by Human Rights Council of the United Nations in 2012 and 2011, probably it was the first step starting in a legal point of view to consider cultural heritage as human rights. Why as human rights? Because there is a relevant problems that the state has to guarantee the rights of everyone to take part in cultural life, including also the ability to access and enjoy cultural heritage. If we compare the democratic constitution adopted around the world, it's difficult to find this kind of rights. Normally, in our constitution, there is the recognition of the liberty of cultural expression. But it's very difficult to find the specific rights of to take part in cultural life, and especially it's difficult to find the duty of the state to guarantee this right. We know that, for example, the Italian Constitution at Article 9 fixed as a fundamental principle the duty of the republics to promote cultural heritage. But doesn't mean that exists a rights as a human rights to culture, to enjoy the cultural heritage for everyone. Also, in a comparative perspective, in the other democratic context in Europe, is it possible to find similar principle in the French Constitution, in the Spanish Constitution, in the German Constitution? But in the European Constitution, it's not possible for the moment to find a specific provisions that say that cultural rights represent a human rights. Is a rights, similar to other rights, but it's not a human rights. Why is so important to categorize cultural rights as a human rights? And probably why? This is my question. And during this seminar, we'll try to explain why this is so relevant. It is true that in the new constitution, in the constitution that was adopted during the last 20 years, we can find similar rights. For example, in the Latin American constitution, in the East European countries, is it possible to find also in some Asian constitution, we can find the provisions that fix cultural heritage as human rights. But there is another problem: the implementation of the constitution provision. There are some problems. In some case, there is no implementation. It's not possible to judge the violation of these rights. So there are several issues on the floor. The last things that I want to stress before giving the floor to Professor Lisinskis: in the international context, now nobody can discuss about the fact that cultural heritage represents human rights. We have to say thanks to the Human Rights Council that in several occasions fixed the principle that in the category of human rights, one of the human rights is the cultural heritage, is the cultural rights. In 2016, thanks of a coalition of 145 states, the Human Rights Council, in a specific resolution, fixed this principle. And starting from 2016, each 3 years, the Human Rights Council check the implementation of this right. Also with a special rapporteur on the cultural rights. So this, why I stressed this fact? Because in the international legal context, now it is very clear the strong relationship between cultural heritage and human rights. I think that we have the duty also to try to change the national legislation and to fix in a better way the implementation of these provisions. But I'm sure that I will come back at the end of this seminar on this topic. And now I want to give the floor to Professor Lucas Lidzinski. Professor Lucas Lidzinski is professor of international law at the University of New South Wales in Sydney in Australia. He is one of the prominent professor on the topics of international law and cultural heritage. And he wrote a textbook on international cultural heritage law. And recently, with Routledge, if I don't not make the mistake, he wrote, he edited relevant book on intangible cultural heritage in different perspective with a different analysis and with the part relating to the topic of the today's seminar. So probably we have no other expert more than Lucas to introduce our seminar today. Please, Lucas, the floor is yours. Thank you very much.
Thank you, Pierluigi, as always, for such a beautiful framing of the issues at stake, and as for the very generous introduction. Hi, everyone. My name is Lucas Lishinsky, and thank you for being here or being online or watching this recording later. And in thinking about this topic of cultural heritage as a human right, cases and procedures, I wanted to really focus on the adjudication of human rights and how cultural heritage plays out in that space. So the puzzle that we grapple with once we center human rights adjudication with respect to cultural heritage is that we in the field of heritage law, we tend to be very excited about heritage adjudication in international courts for a number of reasons. First of all, we feel very validated. Secondly, human rights offers an enforcement pathway that otherwise does not exist in international heritage treaties. And third, human rights law, it has human in the title, so it helps enliven sort of the human dimension of heritage, of which Francesco Francioni was telling us about all the way back in 2011. However, despite this excitement, it is worth thinking more deeply about the place of heritage in a case. And we don't really ask questions about, for instance, whether cultural heritage is part of the facts of a case, or if it is actually a legal claim and a legal consideration. We also don't spend a lot of time thinking in terms of ratione personae jurisdiction, who actually gets to speak for heritage. Even in terms of ratione materia jurisdiction, very few instruments will actually have a right to culture, let alone a right to cultural heritage. So how do we fit heritage within a treaty? And what does it mean to do that translation? And then finally, again, thinking about the life of a case in terms of remedies and reparations, what does it mean to make a reparation in relation to cultural heritage? What is that reparation? To whom does that reparation go? So bearing this puzzle in mind, my thesis today, or what I'm trying to convince you of, is that we ought to think a lot more systematically about heritage and human rights as adjudication, or even as a part of a possible strategy, a possible conversation about strategic litigation, right? Missing the adjudication perspective when it comes to cultural heritage really leaves a lot on the table. It was wonderful to be celebratory of being validated by international human rights courts, but I think we can now move past that and think of what can these courts do for cultural heritage beyond just telling the world that we exist. So what's at stake in relation to this thesis? So thinking more systematically about heritage and human rights as adjudication or even strategic litigation helps us transcend sort of this celebratory phase and be a lot more intentional about the work that heritage does in the world. To kind of try and persuade you of this argument, I want to walk us through a few moves. First of all, I want to talk a little bit about this discourse of heritage and human rights. Then I want to get into these issues that I had mentioned earlier of heritage as fact or law, the ratione personae jurisdiction when it comes to heritage cases, ratione materia jurisdiction when it comes to cases, remedies, and then I want to wrap things up by talking a little bit about what a strategic litigation plan might look like with respect to heritage. Now, the discourse of heritage as a human right. As I mentioned earlier, very few treaties will have a right to culture, let alone a right to cultural heritage. And why is it important to talk about right to culture in opposition or as separate from the right to heritage? Because the right to culture can be kind of anything, right? Whereas heritage is a very specific manifestation of a culture that is kind of covered or by a specific legal definition and does specific work. And because of that, because we have the right to culture in certain instruments, but not necessarily a right to heritage, that automatically will push heritage into the facts of what culture is rather than the heritage itself being the object of litigation. So that's one consequence of it, but I'll come back to that later. For the most part, I wanted to mention that, yes, there are several instruments that will mention culture in many ways, anywhere from the international covenants, the International Covenant on Civil and Political Rights, Article 27, the rights of persons belonging to minorities, International Covenant on Economic, Social, and Cultural Rights, Article 15, the right to take part in cultural life. But then we also go on, the European Convention on Human Rights will fit culture under the right to private and family life. The American Convention on Human Rights will fit culture initially under the right to property, but progressively in recent jurisprudence as a broader umbrella on economic, social, and cultural rights. The African Charter on Human People's Rights will have a right to take part in cultural life under Article 17. And then we also have the Convention on the Rights of the Child, which has very similar language to Article 27 of the CPR, but applied to children. Then we have soft law instruments like the UN Declaration on the Rights of Indigenous Peoples of 2007, the American Declaration on the Rights of Indigenous Peoples of 2016, and the Declaration on the Rights of Peasants of 2018. And of course, there are other instruments out there, but this kind of gives you a flavor of how culture and cultural heritage appear in international instruments. It's worth bearing in mind as well that of all the instruments that I mentioned, only the declarations on the rights of indigenous peoples, the American and the UN, actually mention the right to cultural heritage. Everything else is just the right to culture or cultural life, if that. But nonetheless, despite this paucity of actual mentions of cultural heritage in human rights instruments, the discourse, scholarly and in human rights international legal practice, tends to be very celebratory of whenever culture and cultural heritage are mentioned. But it is, as I argued, a possibly naive kind of enthusiasm. Even if you take these cases at face value and say, look, any recognition of culture and cultural heritage is a good thing. If you look at the substance of these cases, too much leeway is given in these cases to subsidiarity, or in a European context, the margin of appreciation, which significantly weakens the right to culture and the right to cultural heritage. It means that for the most part, whatever the state has to say about culture and its fit in society actually goes. And in doing so, it reinforces the nation state. And of course, that reinforcement is very clear when we're litigating the culture of the nation state. Lautsi versus Italy being a great example of that, in a religious culture as religion kind of, or religion as culture rather kind of context. For those who don't know, Lautsi is about crucifixes in Italian public school classrooms. And in doing so, in reinforcing the nation state, which is something that is very on brand for cultural heritage law, but we also that kind of end up denying human rights laws counter majoritarian premise, right? So international human rights law was created based on the idea that a dictatorship of the majority was a bad idea, and minorities ought to be protected, people who dissent from the majority. And all of a sudden, we have the right to culture being used to actually reinforce the majority. And that's slightly problematic. Then there's also, as part of this problem with the discourse, a recognition of culture at a very surface level is a net in itself, and we seem to be satisfied with that. And this discourse, again, it was really important at an early moment, but I think it has outlived its utility. And I want to walk us through a few examples of how that utility has been outlived. First of all, in thinking about this distinction between fact and law, as I mentioned, the right to culture, for the most part, only allows heritage to be part of the facts of a case. And what is that consequence of heritage as a claim or as a background to a claim? Well, for instance, when it comes to indigenous property right cases, indigenous cultural heritage only helps prove that indigenous peoples were there all along, but we're not really focusing on indigenous heritage itself. So even if that indigenous heritage is attacked, because the case can only be litigated as a right to property and ownership over land, then we kind of assume that once land is titled, the heritage is resolved. But of course, harm to heritage cuts a lot deeper than what a piece of paper giving you title to your land can fix, at least in the short term. And a great example of that is Awastingni versus Nicaragua, which is the first case in the Inter-American Court of Human Rights that recognized collective property rights to an indigenous community. In favor of heritage framed as a fact is the recognition that heritage, especially intangible heritage, can be everywhere, right? That there's nothing really that we do that doesn't connect to our culture in some way. But at the same time, if it's everywhere, it's kind of nowhere as far as the law is concerned, because the law cannot quite capture it. So we end up with this distortion. That means if the culture is sort of everywhere, we never actually get to resolve the issues of control over culture. And another distortion then is, of course, it's these inadequacies of the language of international human rights instruments, to which I'll come back when we talk about ragione materiae jurisdiction. An example of this distortion is this idea of heritage as being part of the factual matrix of a case, which is language from an Australian court when talking about the existence and the proof of indigenous law. They said, sure, we can prove indigenous law all we want, but it will only ever be part of the factual matrix of the case. It will not actually be a legal consideration for the court in its clash with, quote unquote, Western or settler colonial law. But an example of this distortion and the idea of the factual matrix, of heritage being only part of the factual matrix, comes up in Chapman versus the UK, which is a case of the European Court of Human Rights that had to do with the right of Romani or Roma nomads who actually bought land in the UK, and they wanted to park their caravans on that land for part of the year in accordance with their lifestyle. Their heritage was seen as part of the facts of the case. The legislation on landscape protection in the UK was seen as part of the law of the case. And then in the clash, and that legislation became part of the rights of others consideration in the proportionality analysis that the court did, and it prevailed because it was law, right? Whereas Roma lifestyles or Roma intangible heritage was just a fact that the court needed to contend with, but it wasn't a determinative kind of law. And that's another example of how easily it is to capture culture, especially minoritarian culture, and dismiss it under the guise of the margin of appreciation in the European context, with a general terminology being subsidiarity. On the other hand, however, if you want to be more positive about this characterization of heritage as a fact with legal repercussions, we have the case of Lopez Alvarez versus Honduras in the Inter-American Court of Human Rights, which is a case that, among other things, is about the state prohibiting a Garifuna leader from speaking his language to his partner while in prison. So Garifunas are an Afro-Indigenous people in much of Central America, Honduras, Nicaragua, Belize, and I'm missing a country. Anyway, that's plenty of countries for now. So Lopez Alvarez was prohibited from speaking his language to his partner while in prison, and the court saw that as a violation of his freedom of expression. But how did it take that language as intangible heritage into account? Well, it built on a previous case on indigenous land rights that had as obiter dicta this passage that said that in cases involving cultural minorities, the right to equality and non-discrimination, for which every right in the American Convention must be read, means accommodation of difference, of cultural difference. So in that sense, the cultural difference at stake, because it was built into a very general provision of the treaty, as a fact, kind of allowed culture to kind of cut through and create almost a regime of special rights within the general rights treaty, as opposed to the special rights kind of being the exception within the general regime, which is what happens under the ICCPR, for instance, Article 27. So that's an example of a pro, but it has more to do with the specificities and the contingencies of the inter-American human rights system than it has to do with the possibilities of general human rights law. So I really don't want to overplay this this positive example, as positive as it was. Okay, so now going back to this idea of rationem personae jurisdiction, the question of who's a victim and who speaks for heritage. On the plus side, thinking about heritage in these terms, or forcing rationem personae jurisdiction onto heritage, forces us to identify or give a human face to heritage, right? So really forces any human rights body to really bring alive this idea of the human dimension of cultural heritage law. On the distortive kind of side, rationem personae jurisdiction tends to overemphasize property in these cases, because if you have property, you have an owner or a possible owner, so that's almost a shortcut to find a face to that heritage. And property is fine as a proxy for control over heritage, but it can be really problematic in the law because it is a very imperfect form of control, right? Especially when it comes to indigenous communities for whom property is can be a very contested sort of concept. Another distortive effect of this shortcut of property and of rationem materiae jurisdiction, rationem personae jurisdiction more broadly, is that for the most part, international human rights treaties focus on individual rights, and therefore rationem materiae jurisdiction demands that you identify an individual or a series of individuals who get to speak for that heritage. So this idea of heritage as belonging to humankind really doesn't work in a cultural heritage law context once you adjudicate it in human rights law. And an example of that distortion is Landsman versus Finland, which played out both in the UN Human Rights Committee in charge of overseeing the ICCPR, but also a version of it in the European Court of Human Rights. And Landsman versus Finland had to do with essentially intangible cultural heritage as an economic activity, which was reindeer herding. And the question was whether the exploitation of timber in the area, mostly for pulp mills, but also for IKEA furniture, because why not? We're in Finland. It's right next to Sweden. So this exploitation of timber harmed the herding grounds for the reindeer. And then the question ended up being focused too much on the rights of one specific reindeer, Mr. Landsman, at the expense of the entire set or the entire context of reindeer herding, intangible heritage for the Sami people, and the broader economic activities and the pressures of timber exploitation. All right, now thinking about rationem materiae jurisdiction as the next instance in which this relationship between heritage and human rights plays out in cases and procedures. Well, the idea of rationem materiae jurisdiction means that a heritage claim needs to be turned into a recognizable right within a human rights law treaty, right? And those rights so far in the jurisprudence, bless you, have been the right to property, the right to family life, the right to equality and non-discrimination, freedom of expression, freedom of religion, freedom of association. So none of these are rights to culture, let alone to cultural life, to cultural heritage. We have a few exceptions, of course, being, as I mentioned, the ICCPR, American Convention, and the African Charter. So what goes in favor of this bending of heritage in favor into other rights? in favor of that is that it really drives the point, and we can use human rights to drive the point that heritage doesn't really have intrinsic value. Heritage is at its best when it is a platform for a myriad set of human goals, right? One of which will be we like the culture because we like the culture, but most of the time is we like the culture because it says something about our unity as a group, because it gives us a means of livelihood, because of something else, right? Which means then that on the con side, this warping of heritage to fit into a specific right kind of misses out on a fuller range of identity-based claims. And one example here in the area of language and human rights is what happened in the Human Rights Committee with a series of cases against France on the use of the Breton language before, public authorities in France. And that's a case in which those cases were all dismissed. They were all declared inadmissible because France has a weird reservation to Article 27 of the SCCPR. But it also means that effectively Bretons, they were using this case to prosecute a much broader claim for autonomy within the French state. But because the only thing they could do with their cultural identity was kind of bend it into language, they kind of, and that case was declared inadmissible. That was kind of the end of the road for heritage that actually meant a whole lot more than just language before judicial proceedings. And that's an unintended effect of that bending effect. But then also see Lopez Alvarez, which I mentioned earlier, as a case in which freedom of expression really worked out really well for the community in terms of articulating a broader set of claims. All right, turning to remedies. There are a few problems here with remedies, a few questions to take into account. One of which is the nature of remedies that international human rights bodies can order. With the exception of the American Convention and the African Charter, the human rights treaties, they either only make room for recommendations or for very individualized, discrete remedies, which are financial compensation and just satisfaction. That's kind of the end of it. And the European Convention on Human Rights is the major culprit in this area. But if you look at the American Convention and the African Charter, they actually have a competence for much more systemic sort of remedies as well. And I know the European Court of Human Rights has tried to address that via the pilot judgments procedure, and that's had its own challenges, but bear with me. But the American Convention and the African Charter can do a lot more with systemic remedies or systemic change via remedies, and that's what I want to focus on. At the same time, however, even for these courts that do have a competence for systemic reparation, but especially the procedures, the international human rights bodies that do not have it, we tend to focus on a harm to heritage. The remedy to a harm to heritage or harm to culture is simply recognition of that culture. Yes, you exist. Yes, you are valid. Yes, power to you. And that's where it kind of ends. Right? We do nothing to really tap into the fact that because of that cultural difference, these communities have suffered systemic discrimination, and therefore maybe some redistribution might be called for. We tend to stop, to use Nancy Fraser's binary, we tend to be too stuck in the politics of recognition at the expense of the politics of redistribution. On the pro side, this focus on remedies, it's better than nothing, or as you would say in Ireland, perhaps it's better than a kick in the face. However, there is a distortion here in that remedies, they tend to hark back to the ratione materia distortions that we were just talking about, and you make reparations in relation to a specific right, rather than going back to the fuller claims over control and autonomy and the fuller context in which that heritage existed. And an example of that playing out is Laca Onat versus Argentina, which is a 2022, I want to say, case of the Inter-American Court of Human Rights, in which the court for the first time said the broad provision, Article 26 of the American Convention on Economic, Social, and Cultural Rights could be used to really talk about a right to cultural heritage. But even if you look at the reparations in that case, They have more to do with setting up the negative and positive obligations of the state and kind of trying to hold them in balance than actually redressing the major redistribution issues affecting that community and the discrimination they had suffered by the fact of being indigenous. Okay, so with all of that in mind and all those potentials but also pitfalls of human rights adjudication, what might a strategic litigation plan look like? First of all, I would encourage a lot of forum shopping. Let's pit international human rights bodies against each other. It has worked in the past in some early cases, so why not? Let's use that to force the European Court of Human Rights to be more proactive in the way it reads heritage as fact or as law. Let's use it to get the Inter-American Court to be more proactive when it comes to remedies, even more proactive, and so on and so forth. Also, I think it is important to leverage heritage as a fact a little bit more. I know it is a counterintuitive thing, right? Part of the validation of the field is to see heritage as front and center in a legal case. However, to make heritage a fact can lead to the very positive result that Lopez Alvarez versus Honduras was, right? This idea that heritage all of a sudden cuts through everything, and then again you create a special rights regime within that covers the entirety of the human rights treaty, rather than being an exception within the treaty that needs to be justified and that always will lose out to margin of appreciation and subsidiarity. Thirdly, it is important as part of a strategic litigation plan to focus a lot more on systemic remedies. Fourth, as part of systemic remedies, think of heritage as redistribution. Number 6, it is important in doing all of these things I've been talking about, these 5 recommendations, to also go against the subsidiarity of these bodies or remind these bodies of the counter-majoritarian instincts that should animate human rights law practice. Number 7, we need to also humanize heritage beyond the individual. And that speaks to ratione personae jurisdiction, right? And we can do that in the inter-American and African systems by a focus on communities and peoples. There is case law now to support that kind of finding. And in bodies like the European Court of Human Rights, but even also, again, the African Court of Human and People's Rights, organizations can also bring, right? So legal persons can bring. So part of a strategic litigation plan here would be to have communities that live in with or around heritage and for whom heritage means an awful lot, to actually set up legal entities, associations, corporations, and all of that to manage that heritage, and then have them be the victims of human rights violation in test cases. And finally, it is important to use strategic litigation not just to get heritage seen, but also to move past that and litigate control and autonomy, so as to enhance the properties of heritage and make sure that heritage serves a purpose, and that human rights helps leverage that purpose rather than just pay lip service to it. Thank you.
Thank you very much, dear Lucas, for this important consideration. Before to give the floor to Professor Laozikas, I would like to open a short debate with our colleagues, but also with students that are connected, and they can use the chat live to put on the table issues, consideration, question to our speakers. It is clear that now, also thanks to UNESCO legal instruments, the cultural heritage represents a fundamental part of human rights. In my opinion, remains the problems that the implementation of this right is based on the state sovereignty. That means that we have international treaty that fix rules for state, but unfortunately, the international body cannot guarantee these rights to people directly. And it is at the same time, it is true that the meaning of cultural rights have long remained unexplored when compared to civil rights, political rights, social rights, economic rights, and in terms of their scope, implementation, and also justiciability. Probably this happened because normally culture was addressed in the context of other rights, the freedom of expression, the freedom of education, of religion. And it's for several democratic countries, it's difficult to understand that cultural rights represent a different rights and is not only a transversal rights. Also, if we consider another issues that, in my opinion, is connected, the SDGs, the goals of the sustainable development programs doesn't exist a specific goals on the cultural sector. Because when the SDG was adopted by the United Nations, the idea was the cultural sector is transversal sector. So in every goals exist cultural aspect. But in theory, I agree with this approach. But this is another proof of the idea that cultural rights doesn't exist itself, but as a part of other rights, also in the international debate. But and there is another point. When we speak about cultural rights, we have to consider that the concept of culture has to be considered as a dynamic concept, and this is a problem. It's not the same when we speak about political rights, on social rights, and economic rights. So the main object of the rights is very dynamic, and it's not possible to crystallize in a specific and unique definition. So probably also for this reason, it's difficult to guarantee on a national level specific legal instrument for the implementation of these rights. But I don't know if Tiago Burkhardt. Tiago is a researcher of the UNESCO Sharing Intangible Heritage in Comparative Law. Please, Tiago, the floor is yours.
Good afternoon. First of all, thank you, Professor Lucas, for your brilliant presentation. I have several questions that I would like to address you. The first of all, like following the line of what Professor Pedrillo was saying, in your opinion, I would like to ask you, why do you think certain countries kind of refrain to recognize cultural heritage as a human right? There are several debates in terms of cultural rights theory that address some points that lead some countries like to avoid the recognition of cultural rights. And I would like to that you explore a little bit of it. The second question I have is it regards the international cultural heritage law regime. There are some authors like Yvonne Donders is one that addresses this issue that underlines that the international human rights treaties are different from the cultural heritage treaties for several reasons. The human rights treaties recognize the rights to people in an individual bias. Meanwhile, cultural heritage law treaties does not do this. But at the same time, the cultural heritage field in international field, at least, it has changed quite a lot in the last decades, especially due to the 2003 UNESCO Convention. And I would like to ask you if there is a sense nowadays to speak in this division between these treaties still. Professor Lenzerini, for example, speaks about the culturalization of human rights. Is it possible to speak of a humanization of cultural heritage law taking into consideration the participatory agency that especially the 2003 UNESCO Convention has provided. And my third question would be regarding the issue of adjudication and the recognition of a human right to cultural heritage. As Professor Petrillo touched in the beginning, there is a kind of resistance of recognizing cultural heritage as a human right. But I think maybe this is a European perspective. There are other regions in the world that have recognized cultural heritage as a human right, especially in Latin America, we can say this, and have also addressed this issue in constitutional courts in several cases. But the adjudication has also its limits regarding the protection of rights, and when we talk about the adjudication, we are talking about the fact that the political branch, an institutional branch of powers, the executive, the legislative, could not handle the possibility to make it work, make this right work in terms of public policies. So my question would be also, can we move the discussion from adjudication to the ground of public policies? Would it be a possibility to reimagine the right to cultural heritage? Those would be my questions. Thank you.
Perfect. Lucas.
Thank you. Let me start at the end, because I think it helps us think for the others as well. You invited us to think, to move past adjudication. I don't think we've done enough there to move past it. I don't think we have resolved it, right, in any way. And a lot of the ways in which people want to move past something is because it doesn't do anything. It doesn't do the work that it should, right? And I made the case that it's not currently doing the work that it should, right? So it is a valid question. Why not just think about policy instead, or primarily about policy? I think the problem is that cultural policy will serve primarily the nation state, right? Cultural policy, at least as far as I can see, right, serves primarily the nation state, and minorities kind of harmoniously flow into a national narrative, right, through heritage. And adjudication, whether it's a rights-based adjudication or constitutional adjudication, also then rights-based, but whether it's international human rights law or constitutional fundamental rights, it has a counter-majoritarian instinct, right? Which adjudication in this area has lost, but it's still there somewhere, right? And it's important to recover that as a counterpoint to policy. That will have distorting effects on policy, inevitably, right? So better resourced minorities, they'll be able to bring adjudication in a way that less resourced minorities cannot. And that will create distorting effects on how minorities sit in the national landscape if you do only adjudication. And that's a critique that I'm kind of extrapolating from what happens with the adjudication of economic and social rights, especially in Latin America, but around the world in constitutional law. But the same is bound to happen with cultural rights. But that doesn't mean we shouldn't be doing it, because not doing it doesn't give underserved or historically oppressed or marginalized groups, doesn't give them anything to challenge the state with. Because policy is not a great forum to challenge the state. Litigation is better, or tends to be better. But we need to be more intentional about it, right? And it kind of gets us to the first question: why some states oppose to heritage as a human right? Yeah, it's nationalism. Because a human right is kind of majoritarian. Cultural heritage creates the nation for most countries out there, right? It creates the national spirit, and it keeps the nation together. So if all of a sudden you allow heritage as a human right, it can fragment that social cohesion. My argument to that is that yes, cultural heritage is very important for social cohesion, but it shouldn't be used to paper over deeply brewing dissent or deeply brewing resentment or whatever, potential conflict. We can use it to mediate conflict, but not to paper over it. And I think a lot of the opposition to heritage as a human right is because we only use heritage to paper over it and turn it into nationalism and all of that. And then getting to what you were saying in terms of whether the Intangible Heritage Convention or the idea of intangible heritage is kind of seeping through to the rest of the international law of culture. Lenzerini has his book, The Culturalization of Human Rights Law, which in many ways is a rearticulation of a ever interesting and endlessly fascinating conversation about cultural relativism. And that's great, and it's important. But I think what Francioni does with the idea of the human dimension of cultural heritage law is more of what you were getting at. This idea of, so the human rightsization of cultural heritage. And it kind of gets us thinking about, the point you made about Donders, which again is a point about nationalism, right? Cultural heritage treaties as state-centric, and human rights law are about the individual against the state, right? That said, yes, the Intangible Heritage Commission kind of opens a little bit of a door to that, which has successfully been used in some instances precisely when intangible heritage kind of almost disappears into the background of the case. When it becomes part of the factual matrix, it helps leverage a much stronger claim to freedom of expression, equality, non-discrimination, right? And all of that. So I think there is something about thinking about culture in this kind of fluid way. And one instance in which that has happened very effectively is in comparative law, is in Brazil, in constitutional adjudication in Brazil, litigating about Afro-descendant land rights, in which the court essentially used this idea of Afro-descendant intangible heritage as a tether between Afro-descendants and the land they historically occupied. And therefore, not only did they have title to that land, but it was also better title than any non-Quilombola owners or non-Afro-descendant owners that might have title to that land since. So you could title land to Afro-descendants, to Quilombolas, in spite of pre-existing title, which is a much bolder move than what happens, for instance, in countries like Australia, in which indigenous peoples have the right to land, but only to crown lands. If the land has already been titled to a private party, then that's off the table for native title. So intangible heritage has helped Brazil go further and say, actually, not only do you have title to the lands, you also have better title than other people, right? So it is really opposable, really strong title. So I'll leave it at that.
Thank you very much. It is interesting for me also to underline that the international community started to reflect on this topic after the destruction of cultural properties. I remember in 2001, the Buddhas of Bayaman, that was destroyed by Taliban in Afghanistan, but also Palmyra, also the destruction in Syria and Lebanon, when the also International Penal Code decided to recognize as a crime the destruction of cultural properties, not because they are only cultural heritage, but because also they represent cultural identity of the people that live in that context. The case of the Buddhas in Afghanistan was very relevant according to this idea, because in that case the International Penal Code recognized that the main reason of the destruction made by Taliban was not for the against the property itself, but was against the value the identity that Buddha represented, also the intangible heritage and not only the tangible heritage. But now is the time to give the floor to my colleagues Remidas Laodzikas, that I hope is connected online.
Yes, I'm here.
Yes, perfect. Before I would
Good
like
afternoon.
Thank you very much, Remvidas. Before I would like to introduce you, Professor Laodzikas is Professor of Digital Heritage at the Faculty of Communication at Vilnius University, but his research interest very wide, is expert on the archaeology, cultural heritage, history of gastronomy, and also information science. He taught a wide range of undergraduate and postgraduate courses at the different universities in the field of history, cultural and digital heritage, heritage communication, digital culture, museum studies, cultural heritage. So he's a strong expert on different topics relating heritage. One of his books is about the digital memory as a cultural heritage. So thank you very much. And now he plays an important role in the international context as a member of the evaluation body of the ICH UNESCO Convention. Now, if I don't make a mistake, he was elected also president of the evaluation body. I'm very happy. I'm very happy to share this news with all of our audience. So, Professor Laodzikas, thank you very much for joining us, and the floor is yours.
Thank you. Good afternoon to everybody who joined. I will try to share my screen with presentation and to talk a little bit about.
Yeah, we can see.
You can see?
Yes, thank you very much.
Okay, I transform it to full screen. So my presentation, it will not have some kind of deep empirical research. It will have some kind of opinion paper based on my experiences of work in communication and also expert experiences and experiences of different kind of discussions, beginning from discussions in social networks and also in expert-based discussions about intangible cultural heritage. And actually, my point of view is based on a communicative approach. And from communicative approach, when we think about social cultural context of intangible cultural heritage, I like the ideas of Yuri Lotman, the founder of Tartu Semiotic School in Estonia. And Yuri Lotman says that society functions not by objective perception of reality, but by subjective perception of reality, by adding of different meanings to the reality and interpretations of reality. And Lotman divide the society, or by Lotman ideas, society is composed from different groups with different perceptions called as semiospheres. And by this idea, following this idea, the main important thing is the core or central idea of semiosphere, because
Remidas, I'm sorry if I disturb you.
Yeah.
But we cannot follow your presentation. I think that you have to, if you in a presentation mode, you have to put in a presentation mode, because otherwise we cannot follow.
Okay. Let's do it. Now it's fine.
If you can, because we remain at the first.
Okay. Let's try to share. And how is now?
Try to go to the next slide.
Okay. Next slide.
Yes, perfect. Thank you very
Okay,
much.
okay,
Thank
let's go on this mode. Okay, so the most important thing is the central or core idea of semiosphere, which is the main driving thing in creating of meanings about reality, perceptions about reality, and identities inside of semiosphere. Another idea of Lotman is the idea about creolized spaces. Lotman says that some of semiospheres were open to communication. They interact with another semiospheres and create some spaces called as creolized, but actually it's spaces where meanings of one and another semiosphere they are accepted and understood, and another semiospheres they are closed. We are not intended to communicate, and actually in the semiospheres that creolized space are not created. Another thing is that communication between semiospheres is not a direct thing. It's translation, or if you want, it's transcoding of meanings, driven by central ideas, where central ideas works as framing structures. And that means that if one community creates and sends some message to another community, it's possible that all message will be removed by another community because it is not in line with ideas or framing structures of another community. It's possible that this message will be divided to parts, and some parts removed, some parts accepted, and created absolutely new message for internal use in community B. And actually, it's possible that that message from community A will more or less fully accepted by community B. So the central idea of semiosphere is the key element of identity, and intangible cultural heritage is typically shaped framework by the central idea of semiosphere. The intangible cultural heritage in creolized spaces is a rare phenomenon, and actually a relationship to the central idea of semiosphere means that intangible cultural heritage created by one community, by one semiosphere, may be perceived as absolutely incorrect, strange, valid in relation to central idea of other community. And here we have some kind of conflict of identities or conflict of meanings between different communities, between different semiospheres. And actually, from an expert point of view, we have some difficult questions which rise from time to time, from the national levels to the levels of UNESCO, in different contexts, in context of in legal context, in context of evaluation, on political context. Is question about all living intangible heritage the only business of various community, or did this a broader question? Did it allow the external critics of representations of intangible cultural heritage could be a living, I'd say, unethical, unfair, illegal? Are the right and wrong choices for expert, or are a right and wrong possibilities to explore or to understand intangible cultural heritage? And if yes, what are the criteria of ethics or fairness or legality? Because really, when we think about different representations, we have a very, very broad set of representations. And here is, in broader terms, question about positivistic point of view or constructivistic point of view. Did all cultures were constructed and they are good in general, or did we have some objective criteria for evaluation? And we can say that this kind of reality could be perceived as right in general terms, and this kind of reality could be perceived as wrong having different arguments. And in this discussion, I am on the side of positivistic point of view. And I think that when we think about intangible cultural heritage, it is some criteria of correctness, of fairness, and this criteria, they are related to human rights. Why to human rights? Because human rights, they are understood as some universal thing. It's approved by United Nations, and in difference from a lot of other rights around the world, they are universal but not national rights. Yes, I understand that in reality we have a lot of different situations and a lot of different interpretations and a lot of different misunderstandings, but actually when we think about possibility to find some criteria of ethics and fairness in understanding of tangible cultural heritage, I think that it's human rights described in Universal Declaration of Human Rights of United Nations and approved in 1948. So how it does possibly work in different situations, I will show for you two cases. One case is related to Afghanian rubab. It's art of crafting and playing rabab, submitted by Afghanistan, Iran, Tajikistan, and Uzbekistan, and accepted as element of representative list of intangible heritage by UNESCO. But this tradition is prosecuted by Taliban Afghanistan. Similar situations we have, or similar situations, one is the government versus bearers community. Similar situations we have also in occupied territories. I can't only imagine what could happen with person who tried to organize the festival of Ukrainian borscht in the territories occupied by Russia. We have the situation when the factual government of territory not allowed to preserve and to cultivate and some element of intangible heritage, including the elements from UNESCO lists. Yeah, it could be related, or defense of this situation could be related to fundamental human rights as freedom of thought, consistent religion, or freedom of opinion and expression. What could be the role of UNESCO international community? Yeah, it is from previous discussion and previous answers of Luke. It's interesting question about recognition it as a crime, because if we recognize other crimes against humanity, breaking some articles of Universal Declaration of Human Rights in relationship to intangible cultural heritage, we also could be perceived as or recognized as a crime. But actually, I think that in little bit easiest way is important the idea to support the community and migration. In contemporary world, marked by mass migration of people, I think that we can recognize intangible cultural heritage in little broader terms. And actually, it's so important in situations when factual government of the region prosecute the bearers of intangible cultural heritage community. And I think that from UNESCO side, the easiest instrument could be to expand the mechanism of international assistance, including the possibility to apply not only by state party, but also by bearers community in immigration. Actually, limiting this by not less than two criteria. One criteria that community really represent the element of intangible cultural heritage inscribed into UNESCO lists. And another is that element is prosecuted by state party or by occupational government, including prosecution in occupied territories, and it's really a big risk for surviving of this element. Another case related to human rights is when the Belarus community versus experts and non-Belarus communities. And the most clear and most visible example of this is question of strangers. And people will remember discussions in Rabat session in Morocco. We remember discussion about processional giants and dragons in Belgium and France, and discussion about sauvage character of procession, which is form of racism and discrimination. And remember the request to remove from representative list the Duques of Art because community disagreed to change this personage, to change this character. Similar things we have in Lithuania, similar discussions we have in Lithuania. It's related to Užgavėnes, it's Carnival before Ash Wednesday, and Easter Vigil watch in some parishes, and it is some characters of Jewish and Gypsy people who are showed in really incorrect and not ethical way. But here you can see the masks from this carnival. So I think that it's related to fundamental human rights, that all human beings are born free and equal in dignity and rights. And actually it's the right to not to be the subject of bullying on the ground of race, religion, or nationality. What could be the role of UNESCO national commissions in this? Actually, I think one of the most important things is discussion with community members about ethics and human rights, because in some situations it's following the idea that intangible cultural heritage it's only business of communities and nobody can touch it. As for example, from on Facebook discussions, must a real living tradition supported by rural community be changed according to the dictate of political correctness imposed by city officials? Yeah, but I think that this kind of discussions is very, very, very important in the current world. And another thing is, if communities to decide to not change the characters, or if follow his own way, also have a possibility to don't describe international UNESCO lists, as happens in Rabat in Morocco, and that happens also in Lithuania, with one tradition of Easter Vigil night watches, which was not inscribed. Because when we think about UNESCO lists, we think about following of some kind of rules, which, for example, are described in Article number 2 of Convention, and we follow the consideration that intangible heritage is compatible with existing international human rights instruments, as well as with requirements of mutual respect among communities, groups, and individuals. Not inscription of element into lists doesn't mean that we not allow for community to arrange these festivals or something, but it does mean that you are different from our rules and we cannot include you in our lists. So answering to the questions about the threat in expert work, I think that no, all living ICH is not only business of builders. Here are interests of other semiospheres, members of other semiospheres, other communities, experts, governmental structures. It's a field of lot of interests, And actually, if we want to understand which group of interest is right or wrong, I think that the fundamental criteria of ethics and fairness are human rights. And yes, external critics of ICH is a normal part of intercommunication process. If somebody criticizes something, it is not an, I don't know, call for prosecution or for something. It's thinking about how to better allow the needs of contemporary society. And yes, living heritage could be unethical, unfair, and yes, the right and wrong choices for the expert also exist. And then repeating my idea that the line between right and wrong is based on the human rights. So I think that,
Perfect.
thank you. And I'm returning to our slot for discussions.
Thank you very much, Rimvidas, Professor Lauzikas. It was a very rich presentation with a lot of consideration on the table. Well, I really appreciate the case that you share with us, both the case about the Afghanistan case. Also, it's very relevant and probably under-analyzed by the literature, because when the Afghan communities presented the nomination files, as you know, there was no Taliban in the power in Afghanistan, but during the evaluation of the file, changed the government. Taliban came back at the government, and UNESCO decided for protecting people that presented the nomination file also to cover the names of the community and of the people involved in the nomination file. And also now, if you go on the UNESCO website and you check this file, it's not possible to discover the name of the people of the community that practice the element, because as you remember, the practice of this element is prohibited by the government. And effectively, there is a strong problems of about this element, because officially the element is inscribed in the list, is inscribed by the government of Afghanistan, but at the same time, the current government doesn't recognize any relationship with UNESCO.
Yeah, but in broader field, the current government of Afghanistan is not recognized by international community.
Yeah, and also this. Yeah. So, in which way the international community can safeguard the element and the beers of the element and the practice of the element in the Afghanistan context? No, this is so I really appreciate the case that you share with us. The Rubab practice. And also the second case that you share is very interesting. The contrast between the practitioners and the experts. A lot of times we assist to this kind of contrast. Experts in the field of ICH that try not only to assist practitioners, but also to guide practitioners in the practice of the element. Especially when the communities want to apply to the UNESCO list, because as you remember, the UNESCO Convention expressly prohibits to present a nomination file that is against human rights legal instruments. No? So in this occasion, experts suggest sometimes to change the practice of the element, because in this way the element is in line with the human rights instrument, but it is not coherent with the role of expert. But we discussed several times these problems. I would like to open the debate also. Before to give the floor to the other speakers, because Remidas, also Lucas wants to debate with you. There is another question by the table. Jasmine Jalil. Jasmine, she's a researcher at the University of Unitelma Sapienza. She's an anthropologist. She works with the UNESCO chair on ICH and comparative law. Please, Jasmine.
Thank you. Thank you very much, first of all, both Professor Lesinski and Professor Lavzikas. I want to start from the last thing that Professor Lavzikas said, which is heritage and intangible heritage, because of course I'm an intangible heritage scholar, so that is my field of interest, belongs to everyone, not just a community of bearers. It belongs to the community as a whole, is intersectional, doesn't belong to a class or group, and surely it must be submitted in some way to human rights, because per se it can be unfair and or unethical. So this is a just hierarchy, that has to be put in place. But I want to know your perspective. This is for both of professors in this regard, on this hierarchy, on whether cultural heritage law, as it is currently approached, and current international instruments and bodies, also like UNESCO, might actually reinforce in some way a division or a just juxtaposition between, or power imbalance, if you want, between nation states or state parties and minorities, indigenous communities or minorities in general. Also because I feel, but I'm not like a legal expert, so forgive me if I'm naive, I feel like there's usually a misrepresentation or a lack of adequate representation of minorities in the policymaking process. And as a result, a lot of the instruments that we now have might lack, in a way, the cultural or contextual awareness that it's needed to approach culture in a more holistic way, and not crystallize it, as Professor Pedro was saying before, in a monolithic entity. And in fact, also in regard to what Professor Petrillo was saying before, for the SDGs, in the 2030 agenda, UN agenda, culture is not seen as something to protect in itself. It's not perceived as a sustainable development goal in itself, but it's rather an instrument to reach the other SDGs, which kind of like makes me feel like culture is seen from the nation state perspective as a unified entity. So this is my consideration / question for you. Thank you.
Perfect. Lucas, before to give the right to speech Remidas, I would like to ask Lucas to take the floor.
Thank you. I'll come back to your question later, because I'm curious to see what Remidas has to say first. And I want to put something on your list, Remidas. So there's a problem with this conversation between heritage and human rights, right? You gave two examples in which human rights kind of worked, and they're great examples, and I really want to look more into them, especially the Afghan one. But particularly the second example, it reminds me of this thing that the anthropologist Elizabeth Povinelli talked about in this book of hers called The Cunning of Recognition, which is that over every multicultural policy, over every accommodation of cultural difference, hovers an invisible asterisk, which says we will recognize your culture as long as we don't find it too repugnant. Right, and then there's a sense that, so that's kind of the problem, right? There's always an invisible asterisk in liberal kind of legal arrangements and societies. And I think part of the cause of that problem is that human rights is a great idea, but it doesn't, and it's a great yardstick to think about these problems, but it doesn't actually solve them, right? Because human rights still need to be balanced. And the example that you mentioned of Belgium, France, and also the parallel in Lithuania, Yes, there's an issue here of racial vilification and non-discrimination, which kind of work as an exception to freedom of expression, but there's also freedom of expression, so there's a needed balancing, and it all kind of stays in the eyes of the beholder or the eyes of the adjudicator in a way. So I'm kind of wondering, and I want to put this to you as a provocation, whether this potential room for abuse that happens in the arbitration of good or bad here in human rights law can actually be resolved by something that comedians do. So stand-up comedians have this thing that they can tell jokes that punch up, but not jokes that punch down. By punching up, they mean they can go after a relatively more powerful group. They can go after the state, the government. All of that is fair game, but they can't go after a historically disadvantaged group, right? That would be punching down. So in looking at the Belgium and French example, and also the Lithuanian parallel, they're examples of punching down because they're going after a historically disadvantaged group that, compared to the community that practices those elements of intangible heritage, is in a less advantageous kind of position, right? So they're disadvantaged in comparison. Therefore, that heritage is not permissible. And then in the Afghan example, because those cultural practitioners are actually being persecuted by the Taliban regime, then to go after the Taliban regime and say you're not protecting human rights, that's actually punching up. You're not protecting that heritage, safeguarding that heritage. So I wonder if that, and that's my provocation to you, whether that might be a better principle to kind of resolve these issues. And then human rights comes as a trigger to that principle, but not necessarily as kind of the end game here, because it doesn't get us all the way to the answer. Yeah.
Okay. Yes, I agree that it's very difficult and problematic questions. Because when we think about human rights on theoretical level, and it's easy to think about this. But when we try to apply this in practice, that question is much difficult, because recognition, by my opinion, recognition of international human rights as universal value, it's recognized by Declaration of Human Rights. And declaration usually is the kind of document which must be interpreted according to the different cases. Because declaration is in general is theoretical document. So what happens when we interpret it in different cases? That happens in different things. In some situations, it could be real, normal interpretations, not allowing the breaking of human rights, and saving some communities from breaking of human rights. But on the other hand, it could be applied as an instrument of, I don't know, colonialism. Yeah, sure. Because if you find the same community, and if you want to say that they have some things, some things which broke on human rights, we can easily interpret this and make a lot of wrong things. So how to solve this? I don't know. But probably I will relate it, in case of intangible cultural heritage, I relate it with expert-based evaluation. Because when we think about expert-based evaluation in general, every experts, they seek objectivity. Yes, understand that it's theoretical point of view, because we have different experts, what happens in different way, but every expert seeks for objectivity. But at the same time, he or she, they are absolutely subjective, because they comes from particular socio-cultural background, from particular region, from particular kind of education, and a lot of things. And that means that if we have a group of people who seeks for objectivity, but they are different, and if after conversation they agree on decision that, for example, this part of element or this element in general is not compatible with human rights, in this situation I trust in experts. But I think that if we want to solve the problems related to interpretations, returning to Yuri Lotman, if you want to solve the problems of different meanings related to reality, the best way is to invite the people from different semiospheres and to ask him or she to interpret as the reality and to agree about interpretation, an open discussion. And actually, the most important thing when we think about groups of interests, what is a reflection of other communities, not governmental structures, not power structures, but other communities. It's also a little bit touching to questions from before about minorities. That if you look to some tradition, like Carnival tradition in Lithuania, and if you find the Jewish character in this tradition, the first question is what Jewish minority thinks about this. Because this tradition is Lithuanian tradition, is tradition related to dominated nation. It's okay, 80% of population are Lithuanians, it's dominated nation. And let's ask and let's look what is thinking from side of this community. And if members of community or minority way thinks that by this tradition or by this element, they are bullying on the ground of no religion or nationality, it's a strong background to discuss about compatibility of this element with human rights. But it's not easy way. It's expert-based way. It's way which needs a lot of discussions, and probably is not possible to find some, how to say, very clear things here. But I think that it's possible to solve these problems. But we need very lot discussions with members of different communities, with different experts, and as I said before, thinking about the idea of Lotman semiospheres, as more semiospheres, as more people from different semiospheres we include in this process, then probably more right our decision will be.
Thank you, Remidas. Well, several issues on the table. When you spoke, I thought, for example, to another point. Before we said we spoke about the case of the destruction of the Buddha in Afghanistan by Taliban, and the fact that the International Penal Court say this is a crime not only because there is a destruction of a cultural property, but also because behind the cultural property there was cultural value, cultural identity, intangible heritage, and so through the destruction of the property, the aims of the Taliban was the destruction of the intangible heritage that the Buddha represents. But I have a question to you, to both. And this question was generated by the Remidas presentation. There are several practices that represent intangible heritage of communities that are against human rights. For example, the practice of infibulation, that is very spread in the Central Africa, also now. This kind of practice is against human rights. Who say this? The international community. But at the same time represent a part of the heritage of the people that live there. So, in case of destruction of this kind of practice, is a crime, or the fact that this practice is against the human rights doesn't represent a crime? And apart from this case, generally thinking, if the international community decide to destroy a practice, an heritage that is against human rights, this is a violation of the International Convention on, I don't know what, or not. So in other terms, if we try to destroy or to do not safeguard, not more, a practice that it is against human rights but represents the identity of a community of people that live in a specific context, what happens? Is fair, is ethical, or not? So we can consider human rights as a paradigmatic example of what we have to do in any case, or not. I know, but it's a fault of Remidas, because thanks to his presentation, there is too many questions on us. So I don't know if Lucas first and then Remidas. Lucas.
Yeah, I'm happy to go first because I want to give Remidas the final word on this. Okay, so I hear a question as asking, whether heritage that stands in tension with human rights law, whether it can or even should be criminalized. Female circumcision is something that was very much in the mind of the drafters of the convention, right? When they put that human rights exception in the definition of intangible heritage, saying that nothing can be considered intangible heritage if it stands in tension with international human rights law. So in many ways, it's almost like a no-go zone.
Sorry, Lucas. This means only that we cannot nominate this practice in the UNESCO list.
Exactly. So it means it will never be listed as heritage, but it's another question whether it ought to be criminalized, right? Look, as you know, the convention itself doesn't provide for criminal sanctions, so it's something that needs to get resolved at the domestic level. But what the convention can do in that respect is to kind of move the dial against this idea that this is just a traditional cultural practice and people don't get it, because the international legal framework that kind of signals what is an acceptable traditional cultural practice excludes anything that goes against human rights. But in the sense, female circumcision is almost too easy a case, even though you can complicate it in the sense that, we're both white men having this conversation, and we really ought to be asking African women about it. But putting that to the side, I want to focus on two other examples of this tension and potential criminalization. One is something that, so if you look at the practice of elements of intangible heritage that stand in tension with human rights within the Intangible Heritage Convention bodies, there's almost a sense in which, despite the language of the human rights exception in Article 2.1 of the Intangible Heritage Convention, the bodies of the convention have been more, which is a universalist kind of language, right? The bodies under the convention have almost been a bit more relativist than the language would suggest. And one example of that is human towers in Spain, right? Which is an element of heritage in which children kind of climb up the shoulders of like 4 humans stacked up against each other. And of course, there's a risk that they will fall and injure themselves. But then what UNESCO did with that one, or what the Intangible Heritage Convention bodies did with that one, was to balance the right of children to be protected from bodily harm against the benefit that they would get from intergenerational transmission, not just for the community, but for the children themselves as belonging within a community. So that's a way in which a right to heritage or the convention almost creates another consideration to be balanced in a type of human right that normally doesn't actually admit much balancing, which is physical integrity, right? So that was kind of an opening there for thinking within a human rights almost kind of language, but thinking beyond what the human rights technically allows. And that still doesn't get us to criminalization, but I do have an example on criminalization, which is the International Criminal Court's latest judgment, prosecutor versus Al-Hassan, which also has to do with the conflict in Mali. And there, the destruction of property, cultural property, so the destruction of Timbuktu as a war crime was a no-go. He was not found guilty of that, but he was found guilty of the crime of persecution on religious grounds. And it's interesting that the court kind of went out of its way to say that the imposition of a very strict version of Sharia law on the population in Timbuktu was not a judgment against all of Islam, just that specific interpretation of it, and B, it wasn't actually persecution on gender grounds, it was persecution on religious grounds. But then you look at everything that they said about religion, it's actually intangible heritage. So intangible heritage actually played a very important role in making up the international crime of persecution as a crime against humanity. So there is a real way here in which when human rights and intangible heritage work together, they really can lead to a criminalization sort of response in a way that heritage on its own or human rights on its own would not necessarily get you to. So heritage, going back to what I was saying about heritage as a fact, heritage as a fact in this case really gives muscle to freedom of religion in a way that otherwise you couldn't really find. So it can be really helpful. Does that make sense?
Yeah. Thank you. Rimvidas?
Yeah, that for me it's easy to answer. I agree. Yeah, I am on side of people who recognize the universality and priority of human rights. And I think that it works in all possible situations as we have. And we must prioritize human rights in all possible situations as we have. But actually, every situation needs the individual interpretation. We cannot say that let's cut by this way everything, or let's do not cut by this way everything. That I am on side of people who says that the human rights is absolute priority, but every situation must be evaluated individually. And the need for individual decisions.
Thank you. Well, if there are no others suggestions, we can conclude the seminar. And well, really thanks to Lucas and Rimvidas for being part of this seminar, also for the discussion, for the suggestion that you shared with us. Thank you very much. And I remember to our students that this seminar will be recorded, is recorded, and will be online starting from tomorrow on the website of the university. So thank you again. Thank you for your presentation.
And thank you for your invitation.
Rimvidas, we hope to see you soon in Rome again. Next time, we hope that you can be here in Rome, not only today because it's a rainy day, but on the next weeks.
It's every time to nice visit Rome. It's nice to visit Rome.
Yeah, thank you very much.
Thank you.
Bye.
Thank you for the invitation. Bye. Bye.
Thank you. Bye. Bye.